the Human Rights Party of Malaysia's application for judicial review came up for hearing before the Kuala Lumpur High Court Appellate and Special Powers Division Judge Datuk Rohana binti Yusof. Also present was myself as the applicant and a lawyer for Human Rights Party. The senior federal counsel was Puan Nadia Tajuddin. This morning, I had informed the judge that via a letter dated 4th of August 2011, the Registrar of Societies of the Federal Registrar of Societies Malaysia had rejected the registration, the legal registration of the Human Rights Party pursuant to Section 73E of the Societies Act, basically on two reasons that was stated. Number one was that the application for registration was not in order, and number two, that the constitution of the Human Rights Party did not comply with the requirements of the Registrar of Societies. On submission of the application, the Registrar of Societies very clearly stated that all our application papers were in order, and now they are telling us a different story. What I feel is they have not put why the papers were not in order, was not specified why the paper was not in order, because it would give us a chance to put back our papers in order. This does not make sense at all, because the HRP registration was based on the DAP constitution. In fact, 99% of the HRP constitution is based on the DAP constitution. If the Registrar of Societies are telling us that this constitution of the HRP does not comply, it would mean then that the DAP's constitution had been unlawful all these years. It would mean that, because we basically adopted 99% of DAP's constitution, like how Malaysia adopted Republic of India's constitution when Malaysia became an independent country. Our next course of action now would be to file an appeal in the light of the Registrar of Societies letter dated 4th August 2011. Our next course of action would be to file an appeal to the Home Minister further to Section 18 of the Societies Act, which we intend to do by this week. And in our letter, we are going to give the Home Minister 2 weeks time to reply to our letter, failing which we would go to court again to say that there is a presumed decision of the Home Minister to refusing to register the Human Rights Party, and thereafter we will be applying again to court for a writ of certiorari and also a mandamus to compel the Minister to register the Human Rights Party as a lawful political party in Malaysia. In the circumstances, I had submitted to the High Court this morning that the matter should be adjourned to 3 months in order for this present suit before the judge and the intended suit against the Home Minister could be heard together. However, the judge, the learned judge, struck off our application for judicial review, and on the grounds that she would not, that the court would not accept anticipated civil suits as a basis for adjournment. And not only was our civil suit dismissed, but basically in effect to punish us for filing a suit to tell the Registrar of Societies to do his job, we were slapped with a 2,500 ringgit, Malaysian ringgit cost. This to me is not in the best interest of justice in Malaysia, because it directly contravenes Article 10 of the Federal Constitution, which provides for freedom of association, meaning any political party has a right to be registered as to exist and to be registered as a political party.